Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Puja Patel, and today's episode is entitled How to Win and Not Lose an Antitrust Merger Trial. I'm joined today by my co-host, James Hunsberger. Hi, James.
Hi, Puja. Great to be here. Could you introduce our guest today?
I would be delighted to. Today, we're joined by Kieran Gostin, a partner at Wilkinson Stekloff and one of the top merger trial lawyers in the country. Kieran has helped defeat the FTC in the Microsoft Activision merger trial and serves as co-lead in the DOJ's case attacking Visa's debit card business, among other high-stakes matters. Welcome, Kieran.
Thanks. Thank you for having me. That was too generous of an introduction, but I'm happy to be here.
So let's start with some basics. Merger trials move incredibly fast. They're usually on an expedited schedule with discovery often limited to just a few months, and they're decided by a judge, not a jury. Given those constraints, what do you see as the most critical factors that determine whether merging parties win or lose a merger trial?
Yeah, I think the speed of the trials is what makes them so fun and exciting. You'll probably hear me say this a lot over the course of this conversation, but the executives are the most important thing, the business people. So you want to meet them early because you shouldn't be telling them about their business. They should be telling you about their business, and you should be teaching them how to message that. So to do that effectively and get your themes in place early, because you don't have a lot of time, you have to push to get to meet them. You don't impose on them, obviously, but generally, a merger trial, it's a big deal for the company, and you can get them available. And I think that's the key to really developing a narrative from the early stages.
And Kieran, one question we often get is how early should clients be thinking about trial posture? You know, as a deal lawyer, will I be scaring my clients if I bring in the trial lawyer before a complaint is even filed against the merging parties?
I think that there was a time when that was the case in terms of being scared. I think now the way things are, there's so much enforcement, there's so many trials. I think that clients expect it. You also want to choose the right trial counsel who's going to come in and know how to fit in. You don't want a trial counsel who's going to come in and tell everyone what to do, but you do want someone there who can start thinking about the trial perspective. I think the earlier the better, but I'm a trial lawyer, so of course I think that. I think at a minimum, in these merger cases, you always have CID depositions or IHs, which is what the FTC calls them. But essentially, they're pre-complaint depositions. Trial lawyers are certainly not the only people that can defend a deposition. There are plenty of lawyers all across the board that can do it. But having them involved at that stage gives them the opportunity to help the executives start getting their story out right at the beginning. I've been in plenty of cases where certain calls were made in depositions about not answering certain questions, asserting privilege, all sorts of things where maybe you wish it was done a little different because you want to put your executives in the best position. You want them to be consistent from day one, the trial, and having the trial lawyers there, I think, helps do that. So if you're thinking about where you really want to make sure you have a trial lawyer on board, I think it's those sort of pre-investigation or pre-complaint depositions.
And what do you think, Kieran, is the most commonly misunderstood part of a merger trial by clients or even maybe by deal lawyers?
I hate to say things are misunderstood because I don't want to speak for other people. I didn't really come from the antitrust world. I came from doing trials generally, so I can tell you what I think was most surprising to me when I started doing merger trials. I think I was surprised at often when an executive or another company, when it gets called a trial, you get to put them on first. You're the one that calls them, you bring them to trial, you ask them the questions, and then, the other side, the plaintiffs come in and cross them. I was surprised just at how many company witnesses of the merging parties were called by the government, which means they get to put them on first. And I think that has all sorts of implications for how you want to prep your witness to start getting their story out, even on sort of quote unquote cross from the government. And I think we may talk about this later, but certainly in terms of fronting bad material, there's a lot more challenges that go in when it's like that. So for me, that was the biggest surprising thing, and the thing that I worked on the most to sort of get our witnesses ready to deal with.
So this is a special opportunity on Our Curious Amalgam. We have a trial lawyer with us, so we're going to talk about some trial war stories. So you were trial counsel for Microsoft in the FTC's challenge to the company's $68 billion acquisition of Activision, one of the biggest tech deals ever, one of the biggest merger trials ever. What was it like to prepare and litigate such a high-profile, fast-moving case?
Yeah, I've been on a few big cases, but nothing quite like this. There were over 100 people at the trial site. It wasn't just that it was a big merger trial, it was a global investigation. Like, there were antitrust investigations in, I don't even remember how many countries, but that just meant there were so many lawyers involved. The client was very involved, but also in the courtroom, it was packed every day, overflow room, press wanting to talk to you. We don't really say anything to the press, so it's not that big a deal, but it certainly could be overwhelming at times, especially for me. I'm still a fairly young partner. I think that the biggest thing that helped me get through it is I was litigating the case with two of the best lawyers in the entire country, Beth Wilkinson and Rakesh Kilaru. And they're both much better lawyers than me, but even more, they're just really wonderful people. They're generous in terms of their intellect and just how they treat you. And having someone like Beth on, I don't know if you guys know much about Beth, but she's really had an incredible career. And it's sort of like litigating with Michael Jordan if you're playing basketball. It gives you such confidence to know that you got her in the clutch to come in and close things, it's going to work out. And it just gives you incredible confidence to go up there and sort of perform in the way you hope to, knowing that you've got this incredible backstop behind you. Not everyone obviously gets that luxury, but I've been very lucky to work with people who are much better than me. And I think that always makes it a lot easier. My advice to people is always find lawyers that are better than you.
Good advice.
From an outsider's perspective, this case seemed to have all sorts of antitrust issues, vertical theories, issues around market definition, issues around company documents, the list goes on and on. From your perspective, what were the issues and or evidence that the judge focused most on? And what do you think ultimately moved the needle in Microsoft's favor?
There's lots of things, and we're lucky we had a great judge. The story of this case is there are a lot of great people involved other than me. Judge Curley is a wonderful, thoughtful judge, and she took the case very seriously. I can't say what moved her, but I think it was two things from my perspective that were biggest in our favor. One, our executives were excellent. The people who work at Microsoft are genuinely wonderful people, and they're very passionate about their business, and they were great witnesses. Our first witness up, I think, was Sarah Bond, who is a big strategy person there. And I think they called her, and then we got to put her on. And I think at the end of her testimony, we were way ahead, and the FTC had a real mountain to climb. And I think that's really what put us in a great position from the start. And what she did well is she really just explained the business to the judge. She answered the judge's questions directly. She explained why the deal happened, but she also just made the business really accessible right from the start. And then I think the second thing is the numbers just didn't add up at the end of the day. Their expert had a model, and at the core of this model, there's this one assumption that the entire model relied on. And I would think Beth's entire cross, essentially 2 or 3 hours, was based on getting the witness to admit that this number was just plucked out of nowhere. And ultimately, he did admit it. And during closing arguments, the judge spent, I think, at least half the time asking the FTC questions about where that number came from, and no one could really give a straight answer. So I think most of the time you're going to hear me say that it's not about the quantitative analysis, it's really about the people. But there is a sense in which if you're going to bring a model to trial, it better withstand scrutiny, because trial is a battle for credibility. And if you put up a model that has a real fundamental problem at its core, that's going to taint your whole case. And I think it did. I think it did in this case.
So one issue that often comes up in merger investigations and in merger trials is, are there any natural experiments, past experience with the company that speak to how the company might behave following an acquisition? I understand one of the key issues at trial was the history around Microsoft's acquisition of ZeniMax in 2021. Could you speak a bit to how this issue played out at trial? How did the FTC seek to use that acquisition against Microsoft? How did Microsoft respond? And what seemed to really resonate with the court on that issue?
Yeah, maybe I'll just give just a brief moment of background about the ZeniMax acquisition. ZeniMax is another game studio like Activision. It has very popular games as well. It's Bethesda Studios, it's often known as, and it has some really successful games. I think it was a $10 billion acquisition or something like that, but don't quote me on it. So it was a big acquisition as well. Not as big as Activision, but it was a big one. And ultimately, it wasn't challenged by the government. And at the time, there were questions about whether the games would go exclusive or not. And this case is all about Microsoft Xbox buys a game studio. The question is, are they going to release the games that studio creates on just Xbox, or is it going to be on Xbox and PlayStation and a bunch of other places? And ultimately, they made the decision, at least for a period of time, to take a lot of the ZeniMax games. It's called exclusive. They put it straight on Xbox. Basically, the government, this is sort of the key narrative point that the government was trying to make in the Activision acquisition. They basically said, look, you can't trust whatever Microsoft says, because whatever they say, they've had this situation in the past, and they've done it. They've taken them exclusive. They're going to do the exact same thing here. Don't believe anything they say. And it was challenging in a ways, because the deal model that underpinned the ZeniMax acquisition assumed that games would be on both platforms. So there was some reason for them to be making these arguments. How did we deal with it? I think we tried to just attack it in as many ways as we possibly could, and to attack it right up front. So we, at the end of the day, attacked the numbers. We attacked the type of games. We explained in multiple different reasons why ZeniMax was not a good comparator. And we found other acquisitions that Microsoft had made, specifically Minecraft, where we had not kept the games exclusive. I think Beth always says that you have to take a weakness and make it a strength. And usually the reason that is because if it's a weakness, it's sort of a core fact in the case. And a core fact in this case is that Activision is huge. Like Call of Duty is a giant game. So I think we actually showed why, because it was so huge, it was just financially impossible to take it exclusive. The game was so successful on PlayStation, it made so much money on PlayStation that you could never make up for that by taking it exclusive. And that really required our executives to explain how the business works and why, yeah, maybe sometimes you want a game exclusive, but there are other times when that's not the play, and here are all the reasons why. I think, in the opinion, the judge ultimately agreed that ZeniMax wasn't the right comparator, and we spent a lot of time talking about that before the trial and how we were going to do it. So I was very pleased that she saw that, and I obviously think she got that right. And the proof's in the pudding, because Call of Duty is on PlayStation and is going to be on PlayStation for the next 10 years under contract at least. I think she did get that one right.
That's really interesting, and I appreciate that perspective. So thinking a bit about how you prepare for trial, what types of evidence you put forth, and we alluded to this earlier, but there's always debate about what carries more weight in a merger trial: internal documents that show how the business sees the market, or economic modeling and expert testimony that tries to quantify the competitive effects. In your experience, how do judges tend to treat these two categories of evidence? And do you think that, from the judge's perspective, one tends to be more persuasive than the other in determining the outcome?
This is probably because I'm a trial lawyer and not an antitrust lawyer, but I think the business's documents and testimony and past conduct is what persuades the judge. I think that's more intuitive for all of us who don't have an economics degree. But that doesn't mean that they don't have to work in tandem. I think the internal documents, the testimony is what persuades the judge. But then the economic evidence, the quantitative analysis, that's what gives everyone comfort. And if that holds together and it supports what's going on in the internal documents, that's really successful. I think good economics analysis really explains to the judge why what seems intuitively correct based on the business documents is actually economically true. Now, you don't always have the luxury of that being the case because maybe the internal documents aren't great for you, and obviously there's a whole host of issues you have to deal with there. But as much as you can, you want to reconcile the two and show why they're supporting each other.
So pivoting to witnesses, Kieran, you talked a little bit about the strength of the business executive witnesses from the Microsoft Activision trial. In your experience, what makes both a fact witness and an expert witness a good one? And how does that differ based on the two different types? And sort of related to that, are there things, do you have tips, advice that trial teams or in-house counsel can do to better prepare their witnesses?
Yeah, I mean, I don't know that I'm in the business of giving tips because I'm sure there's great lawyers out there, but I can tell you what I do and how I think about them. I think that for expert witnesses, they tend to be brilliant economists, and they know they're already the smartest person in the room. Their challenge is not showing that they're the smartest person in the room and being straightforward, simplifying things, making it easy for everyone to understand, making the judge feel good about their own grasp of the economics, I think is a really important thing. So the judge actually feels like they intuitively understand it and can explain it themselves. You always want the decision maker, whether it's a jury or the judge, to feel like they're coming to the decision themselves, not being told what the answer is. So doing that in a way that allows them to do that, I think, is really the expert's job. In terms of business executives, every fact witness is sort of a different person and a different problem, and there's different things you have to deal with. But the most important thing is that they come across as authentic. And the best way to do that is to be authentic. And this, I think, would be my number one tip for people is don't go in and tell your witnesses what you think they should say. Listen to what they have to say and teach them how to message it. If you're in witness preps and the witness is not talking 75% of the time, I think something's gone wrong, in my personal opinion. I try to let the witnesses do as much talking as I can, take what I can from them, and show them how they can use it. I'm never going to know the business better than them, but what I can do is tell them how things are going to play in court and teach them how to persuade people in a meaningful way. So that's what I look at as my role, and I sort of very upfront with the witnesses at the start about that as a general matter. I tell them that's how I want to do things, and I think they like that. I think a lot of executives have lawyers come and talk at them, and I'm sure, like I said, there's some really great lawyers, so I'm not saying that people do this all the time, but I think that's their perspective. They feel as though they're being told what to say sometimes, and that's not a good place to be with a witness.
So we're talking about the importance of business executive testimony, and there's a common scenario that comes up in merger trials. A business executive is going to be a lead trial witness, but has some unfortunate documents about close competition with the other merging party or the likely effects of the merger. How do you handle preparing a business executive for direct and cross under those circumstances? And most importantly, how do you help the witness maintain credibility with the judge?
Yeah, the typical answer in trials is, you want to front it. You want to get it out before the other side gets it out, and you want to put it in context. The challenge, as I was sort of alluding to at the start, in merger trials is oftentimes the government's putting on your witnesses first. So that's an extra layer of getting them ready to either put the evidence in context, explain it in some way, or in some situations just saying, that was my opinion then, it's changed, and explaining why and just being really straightforward about it. But you have to practice with them finding ways to do it, because if it's after a 4-hour cross and they haven't done it, and then all of a sudden when I get up there and start asking you questions, now you have all the explanations, that just doesn't ring true to people, even though, frankly, it's nerve-wracking being up there, and sometimes I think it's just hard to get out if you have a really good lawyer asking you questions on the other side. But that's sort of the perspective. So I think preparing them to do that is one thing. And the other is don't put it all on the witness. Figure out ways to get it out early yourself as a trial lawyer. Say it in your opening. Tell the judge about it. Make sure it doesn't come as a surprise when it happens. Have prepared the responses ahead of time, and sort of, even if you don't say, hey, this document's going to say this, but this is the truth, the themes that are going to come out when you do explain it, you want to hit those early. So you really, in my opinion, all business executives can be good witnesses. It's really the trial lawyer who both prepares them, but also just puts them in a good position so that when they're there, everything they're saying is consistent with everything else that's being said.
Thanks, Kieran. That's really good and practical advice. I think now we're going to shift to a rapid fire segment, and I'll turn it over to Puja for the first question.
Yeah, we're going to ask you a bunch of questions, Kieran. Want your first instinct answer. First question, biggest litigation trap to avoid?
It's the one I've been talking about, telling your business executives what they should say and what their business is about. That's the biggest thing I've seen.
What's the most underrated skill or quality for a successful merger trial lawyer?
Being humble. There's a lot of really smart people out there who you're going to be working with. Making sure that you don't think you have all the answers is really important.
What's the one thing merging parties can do now before a deal's even signed to make their lives easier if they do end up in court?
I have good experience for this for Microsoft. I think what you want to do, and I didn't do this, the really wonderful people at Microsoft did this. They figured out the weaknesses of their case before they even signed the deal, and they addressed them right away. The head of Xbox, and I think the CEO as well, called Sony the day after the deal was signed and said, we're going to give you Call of Duty. They knew that was the weakness of their case, why it would be challenged, and they addressed it the first day. They didn't wait at all, and then they continued to do that all the way up. So they were really, really smart. They're really great lawyers at Microsoft, and they had a wonderful strategy for doing that. But they were very upfront. They were very honest with themselves about what the challenges were going to be, and they went out there and dealt with them.
What's the single worst thing a witness can do on the stand?
Tell an untruth.
Probably an obvious one.
Good simple answer for the rapid fire segment. What's an analogy or metaphor that's actually worked in court?
I tend not to, I'm not sure I've seen a ton of analogies and metaphors, but Beth is really good at weaving pop culture references into her closings. She's used Michelle Obama's "When They Go Low, We Go High" really effectively. I've heard her reference the song "Things That Make You Go." Now, she can do it because it's authentic to her. These are things that she uses every day, and it comes across as really authentic. So you got to find ones that work for you. But those have been a couple of my favorites where you sort of get the popcorn out and you're like, oh, this is so much fun to watch.
Do you have any sort of personal ritual you do the night before trial?
Yes. This is cheesy and embarrassing, but I do yoga and try to get to bed early, which I know is so embarrassing, but that's the truth.
If it works, it works. What's a merger theory you think we'll see at trial soon, but we haven't seen yet?
I'm not really an antitrust expert, so I'm not sure I'm the best person to answer this question, but I think there's been a lot of sort of hints to non-traditional theories where they're talking about labor or all these other impacts and moving away from quantitative analysis. I think ultimately when you got to trial, it's become much more the fundamentals and what people have done for a long time. But I think we're going to continue to see, depending on the administration, people trying to stretch it. And at some point, we're going to see a case that really leans into those alternative theories. I don't think we've really seen that yet, although you guys know antitrust law much better than me. You could probably tell me an example that says I'm completely wrong.
No, I think that's a good answer. Kieran, you've started to open up a little bit, share some of your personal rituals. At the end of every episode, we like to take a couple minutes and get to know our guests even better. So we have two standard questions we ask all our guests. The first is, tell us something about yourself that we wouldn't know if we only knew you in a professional setting, other than yoga and early bedtime the night before trial.
You would not know it, but I was born in England. I don't have an English accent, but I come from a family that comes from two totally different parts of the world. My mom's side of the family were farmers in the north of England, and my dad's side of the family, his dad was a factory worker in Queens, New York. And those two sides of the family could not be more different, but could not love each other more. So that's something that I think actually has a real impact on me in my life, because I've lived with my family in two totally different ways of living. And I think it sort of has helped me interact with a lot of different people in a lot of different ways.
Sounds like a really useful background for a trial lawyer interacting with all sorts of different people.
Indeed. Kieran, we're going to ask you, we call this segment the Curious Hat.
And now it's time for the Curious Hat,
where we ask you a fun question about yourself that you haven't heard before. We haven't previewed the question. So the question to you, Kieran, is if you were given $50,000 on the condition that you spend it in 1 hour, what would you spend it on?
Oh, $50,000 in 1 hour. It has to be something I consume within the hour, or just that I would spend the money within the hour and then use it whenever I want to.
Consume it.
I don't know. I'd probably do like a lifetime gym membership or something. Those things are so expensive. So that's a stupid answer, but that's probably what I would do.
Not the worst way you can spend $50,000. But anyway, so to close, Kieran, thank you so much for joining us today. This has been, at least for me personally, a hugely helpful session on merger trials. Thank you, audience, and hope everyone has a good day.
Yeah, thank you, Kieran. This has been really awesome. Appreciate it.
Thanks for having me.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.